started. Thank you all for spending a long lunch hour with us today to talk about pro bono bankruptcy program through Montana Legal Services and to learn about Chapter 7 and the basics of helping somebody file for Chapter 7. I'm going to start by introducing our wonderful presenter, and then I'm going to give a little bit of information about Montana Legal Services and who we are and what we do for those of you that don't know or haven't attended the 9 million CLEs that we've gone over this over the years, so I'm sorry if the information is repetitive. But we'll talk a little bit as well about Rule 6.1 and about our File Your Own Bankruptcy program, which Jennifer participates in and can talk to you about her experience as a volunteer with that before diving into the material. So everybody in the room has hard copy materials. Everybody online should have those available to them as well, and we'll provide contact information afterwards if anybody has questions about how to get in touch with me if you need the materials or if you have any follow-up questions. So first, to introduce Jennifer. Jennifer is the founding member of the Beardsley Law Office, which was opened in 2010 in Missoula, Montana. She graduated from Duke University School of Law with honors in 1997. Jennifer has devoted her career to helping low-income clients with a special emphasis on seniors and veterans. She's practiced all over, including Georgia, Alaska, and Illinois, and Montana Legal Services was lucky enough to have her on staff for several years. She's represented individuals with HIV and AIDS in Atlanta, in Georgia, and survivors of domestic violence in Alaska, and consumers in Chicago, Illinois. She moved to Montana in 2005 to work for Montana Legal Services Association, where she worked as a consumer specialist. She knows her stuff. No matter where Jennifer has lived, she's always been an advocate for social justice in both her professional and personal life. And she's served on the boards of multiple community organizations, including serving as the chair of the Yellowstone AIDS Project in Billings. She's also licensed to practice in the state of Montana and U.S. district courts in Georgia, Illinois, Alaska, and Montana. So that's Jennifer, and before I turn it over to her, a quick overview of Montana Legal Services, where I work as the pro bono coordinator. Montana Legal Services is the Legal Services Corporation-funded legal aid provider for the state of Montana. So we are it. We serve the entire state, and we provide free civil legal services to clients living below 125% of the federal poverty line. So what that means is we do a lot of family law with an emphasis in clients that are leaving domestic violence relationships. We work on consumer issues, Fair Debt Collection Practices Act claims. We do a lot of landlord-tenant, particularly with a focus on subsidized housing. We also do Indian law and have circuit riding attorneys and that run the High Line all the way down to Lame Deer on a regular basis, and then we do a whole host of other things as well. But we rely very heavily on pro bono attorneys in Montana, and we're really lucky because Montana attorneys really step up and help out, and that is because we just don't have enough attorneys, and we never will, to cover the need that we find in Montana. So a lot of attorneys help us with cases that we can't take, and we rely on the Montana Rule 6.1 to do that, which says attorneys should, they do not have to, but they should do 50 hours of pro bono a year to clients that cannot afford to pay. However, we understand that 50 hours is a lot, and so we try and make it as easy as we possibly can to do a couple hours here or there when you have time in an area that you find interesting. So the program we're going to talk about today has to do with Chapter 7 bankruptcy. And I don't know if any of you have ever looked at the bankruptcy forms on the court's webpage, but they're very thick and very intimidating. But we have a lot of clients that would benefit greatly from having their debts discharged. These are people that are never going to be able to pay. They've sunk deeper and deeper into debt, and they just need a fresh start. So typically how they come into legal services is we have advised them on the underlying debt, and then one of our attorneys recommends that they file for Chapter 7 bankruptcy as the next best step. When they encounter those large forms, a lot of people are very intimidated and don't follow through or are really hesitant to file because of how complicated it appears to be. So our pro bono bankruptcy program asks volunteer attorneys to provide them with some guidance as they proceed through the paperwork. And the ways we do that are kind of dependent on the attorney's preferences. Jennifer does a lot of the appointments over the phone because we help clients that live all the way out in Sydney, and she's able to walk them through the process over the phone. We have attorneys that meet with clients in person and just fill the paperwork out with them to help them get to a point where they can file. And then legal services reviews and makes sure people are successful in filing and can provide some administrative support and things like that. So that program is wonderful, and it's hard to express how much of a difference it makes when you look at the 3 hours an attorney may put in and the $80,000 in debt that can be discharged with one client. It's a really big payoff for a client, and it's a fairly small lift for attorneys. So if you have any interest in doing that kind of work, please let me know. We'd encourage you to get involved with that. It's a small amount of time and a big difference for the client, and we're going to talk a lot about how you can do that through this presentation. So with that, I'm going to turn it over to Jennifer, and a few quick housekeeping things. Don't eat or drink in here. I've been told it's against the rules, and it's a small group, so we'll see you. And two, if you ask a question, I think we need to have you talk into the microphone, so I'll bring it around so that people that are watching the live stream can hear the question. I think we'll save some time at the end for questions, but do you want to take them throughout?
It would be easier to take them throughout as well. Just given the density of the materials, if someone has a question, they might not want to hold it till later if they want to follow along.
And I will bring you the microphone, which I'm now going to turn off before I forget. Okay.
And just another quick housekeeping for those who are on the stream. The website where you can get the documents, if you have not already downloaded them, is courts.mt.gov/library/CLE. And if you do have questions remotely, you can email smclain, which is MCCLAIN @mt.gov. And I assume even if you have questions afterwards, those could be sent to her as well. So as she said, I am Jennifer Beardsley. I do primarily consumer work here in Montana and a lot of bankruptcy, both Chapter 7 and Chapter 13. A basic Chapter 7 is what we call a walk-away bankruptcy or a full liquidation. Those are the forms we're going to go over. The clients from legal services, they do not help with Chapter 13, so it's just the Chapter 7. And most low-income people, that's all they need anyway. Given the clientele of legal services, it's very rare that someone would need a Chapter 13. She discussed the legal services role in the pro bono project. I find it very helpful so that the clients have been pre-screened. So they've already been screened for income, and they've already been screened that the Montana Legal Services thinks they need a bankruptcy. So it's not the obligation of the pro bono attorney to figure out, do they need a bankruptcy? At that point, they're more looking at how can you finish up your bankruptcy? Because by the time they come to you, the client should have filled out all these forms that we're going to look at today. On the forms I filled out, it's just a sample. Just note here, nothing in this packet is legal advice, and the forms aren't necessarily what you would see if the client came in, because this is a particular example. I tried to do an example that represents a legal services client. Hold on one moment, please. I wanted to start by just looking at the Montana exemptions. One of the things that legal services clients have a difficult time with, oh, I forgot one other thing, I'm so sorry. The pro bono attorneys can do the reviews over the phone like I do. I do a lot of the remote communities. But they also can do them in person where there's legal aid offices. I know that Chuck Munson, who's here and works for the state in the Consumer Protection Division, does the reviews here in Helena in person. And I think both he and me and maybe some of the other experienced bankruptcy attorneys would be happy to mentor you if you do want to try this process. So that way, if you have questions as you're going through, you can stop and say, I'm going to have to check with somebody, and get that answer so that way you're not, of course, giving out advice on something that you don't know the answer to. Excuse me. I think a big tip for success when dealing with legal services clients is to remember that you're speaking at a level that's understandable to the client. I always say that's about a 6th to an 8th grade level, depending on the material. It's hard to take bankruptcy material and take it down to that level, but it's important so that the client understands the process and what they're going to have to do on their own to complete the process. So I wanted to look at the Montana exemptions. One of the things that you have to do in a bankruptcy is list what you own. And we'll go over that when I'm looking at the particular forms. But once you list what you own, you want to tell the court why you get to keep it. And that's important, and it includes citing the law. And a lot of the clients have difficulty with that. You know, we try to explain to them, and they get instructions, but it's not easy to just all of a sudden become a lawyer. And it's not easy to understand perhaps which exemption applies to your situation. So there's a list of the exemptions in the materials. And I tried to star the ones that are most common for legal aid clients. And the first one is the homestead. If the client owns their home, they must in Montana have a homestead declaration on file with the county clerk and recorder's office. So that's a little question that you want to ask if they own a home, just to make sure that they have a homestead declaration on file. It's a cheap document to file. It's about $12, and it's really simple. You just have to include the legal description of your property and then sign it in front of the clerk and recorder or a notary. It protects up to $250,000 of equity in a home. So in Montana, that's pretty much almost every home because most people owe money against their home. So even if it's worth more, the equity wouldn't be more. The second one that's very important is the household goods. Everybody has household goods. I often have clients say, well, I own nothing. Well, you own something. And so if you own a couch or a bed or a dresser, or you own your microwave in your kitchen or your lawnmower, all of these are things that you need to list to the court. And it's important to realize you're not listing what it costs to replace that item. You're listing what it costs to sell that item or what you could earn from it. So if your couch is old and you can sell it for $20, that's all you have to list for the value of the property. In Montana, you're allowed up to $4,500 of this type of property, and I can tell you it's very hard to get to $4,500. Most clients have under $1,000 of this type of property. I did not star maintenance and child support, but that is an important one for legal services clients. If they're owed child support, such as an arrearage, then you list that as one of your assets. In Montana, in fact in most states, if not all, child support's 100% exempt. So if the day before you file your bankruptcy, your ex drops $3,000 into your child support that they owe you, that's exempt and the court can't take that money. And that's important for cash because in Montana there's not what's called a wild card exemption. So there's no way to exempt cash other than if it's a protected source of income. So if you've got cash sitting in your bank account, that could be taken by the court if it's over, you know, they understand if you have $500 or less in your bank account. They're not looking to take you down to zero. But you need to be aware that when you file, you don't want to have much money in your accounts, especially if it's not protected. The motor vehicle is also an important one. Most people own a car. In Montana, you're allowed up to $2,500 for your vehicle. That's not a lot of equity, but it does cover most people's cars because a lot of people owe money against their car. And if they do, they're often upside down, so they owe more than the vehicle's worth. And that's pretty typical. If it's a married couple, they can have two cars. The net earnings, this is important to protect most of the cash. It protects 3/4 of the cash you earn from your wages. So, which is the greater of 30 times minimum wage. So it's basically 3/4 of it is protected. Another important benefit is life insurance. Not life insurance, excuse me, retirement benefits. A lot of people have a 401k at their job, and it's also 100% exempt. And you can see there's several different types of retirement. The big one important for most of you would be public employees. And we do see quite a few public employees going through the process. So different types of retirement are, of course, important. The last one I think is really important is Social Security. Several legal aid clients, their source of income could be Social Security or disability. Those two are 100% exempt in Montana. So, you know, if they have Social Security built up in their account, that is exempt, so you don't need to worry about those cash limits. Those are the main exemptions that we'll be looking at, and when we get into the documents here in just a couple minutes, we'll show where these go and how they get put onto the forms. Does anybody have any questions?
I'm just going to repeat that question, or have you repeat it, because I'm not sure I heard it.
You said 401ks were exempt. What about IRAs?
Yes, they are. IRAs, Roth IRAs, 401ks. They go in the general retirement benefits, but that's actually a good question. And pensions are mostly separated out. But if they have a pension account from a private employer, that too goes in the general retirement benefits category. So, you know, if you retire from a mine and you get pension that way, it's different from if you're working for the state, obviously. It's a different pension. So,
sorry, Jennifer, I think we have one back there.
Okay.
Sorry.
No, that's good.
Is there a time period when the homestead declaration has to be filed before you file the
It could be
bankruptcy?
filed the day before.
Okay.
So there is no time period before. It just has to be before you file the case. And that leads me to something else that's important. The clients are told, and they should be aware, that they have to do what's called credit counseling before they file the bankruptcy. That's something to keep in mind. I usually just ask them. And when we're going over the forms, you'll see where there's a form that says, I've done the credit counseling. It can be done with any numerous numbers of consumer credit agencies. Almost all of them are certified in every state now. And the cost varies from $10 up to $50, depending on which organization you do it with. But it is required. You can't file a bankruptcy if you haven't done the credit counseling. All right, the clients are given the next 5 pages in the materials. I went ahead and pulled mine out. Otherwise, you'll be flipping back and forth a bit. It's up to you. You can leave them in your book. The clients are given these documents. They're given a whole slew of documents, quite frankly. They're given documents about why they're filing bankruptcy. They're given documents about what to do before you file bankruptcy. There's a lot of documents people need to gather together in order to even fill out these forms. They need their pay stubs. They need their tax returns. They need bank statements. So they get that list of forms, though, from legal services. So your role is not to say, do you have all your forms together? Did you use your forms when filling out these papers? You should assume that's what they did. If you get to a point where something looks off, of course you'd want to follow up. But they are told about the bankruptcy court's website. There are materials on the website that can help someone file pro se and to talk about the forms that are available. When we're going through this list here, you'll see that the clients, of course, can click on the links to get to the forms. They're sent these electronically. So several times in here it'll say, click on the link, and obviously that's what that's for. There's only one bankruptcy court in the state of Montana. It's located down in Butte. But the state doesn't make everybody come to Butte to do their meetings. In bankruptcy court, in a case like a legal services client, they don't go to court. They appear in front of what's called a trustee. And the trustee is an attorney, and he or their job is to see if there's anything available in the client's estate to give to the creditors. Almost all legal services bankruptcies are called no-asset cases. They don't have any non-exempt assets to give to their creditors. And there's no money available to give to the creditors. And so those are the easiest types of bankruptcy. And so for the client, they just need to know they have to appear at that meeting, and it's important to communicate with the trustee if the trustee communicates with you. Pretty basic. They do the meetings in Billings, Butte, Missoula, and Great Falls. Which means, as you can tell, all of eastern Montana has to come to Billings, and all of northwest Montana has to come to Missoula. And the High Line mostly all goes to Great Falls. So it is an expense for the client if they live remotely, but that's just the way it is. No, Helena has to go to Butte. So there are no meetings in Helena. All right. So we're going to flip ahead to the materials, so you can just skip those next 5 pages, and we'll talk about them as we go through. All right, so these forms are the forms that the client gets from legal services. They are given them in paper form and electronically. Most clients are now choosing to fill them out electronically, which is great for you. Pro se filers can fill it out by hand. Of course, attorneys file everything electronically in bankruptcy court, just like they do in federal court. But the pro se filers can do all theirs through the mail and can still handwrite the documents. I try to encourage them to use the PDFs because it's easier to read, obviously, and easier on the court. And the court prefers it, of course. So the first form is called the Voluntary Petition. And the Voluntary Petition is basically the background information on the client. And when reviewing it, you're not telling them to fill it in. It should already be filled in. So they'd have their name filled in at the start with their Social Security number. In this sample, I, of course, didn't create a full Social Security number. That's phony. The client's full Social Security number would be there. I always ask them to confirm it's correct because it ties into the entire case. They have to make sure their Social Security number matches their Social Security card. The next page is just addresses. Again, just confirm that it's a correct address. This is not a difficult form if you read through it. Obviously, we don't have time today to read through every single line of these documents. But they are fairly self-explanatory, and the client is usually pretty good on this first form. Everything's usually filled out correctly. The instructions give them guidance on how to do that. Everybody's filing to Chapter 7. If I could get these clicks correct. On page 3. And most legal services clients do not have to pay a filing fee. If you're below 150% of poverty, which is a formula obviously set by the federal government, they qualify to have the fee waived. And that's important because the filing fee is $335. So that's not a small amount of money for most legal services clients. That's quite a bit. You'll find that almost all legal services clients can get that fee waived. It's based on net income and not gross. So almost every client would qualify. It's important to note that they haven't filed a bankruptcy in the last 8 years. That's the next question, number 9. And if you have to wait 8 years between filing in order to file another Chapter 7, so I always just confirm, have you filed in the last 8 years? Most of them have not. They know that from the materials. It shouldn't be an issue. Again, I'm not going to go through every line, as we just don't have time to do that today. Most clients do rent their residence, and that's important to note for the court's purposes. This next form, which is page 5, this whole thing is just confirming that you completed the credit counseling. So you'll see there's only one box checked because everybody that's filing through legal services will have that credit counseling beforehand. So you just have to ask, did you do the credit counseling, and let them know that the certificate needs to be filed with the petition. Again, they've been told that, but sometimes they need some reinforcement. Most all legal services clients fall in this lower level of what their assets and their liabilities total. But again, those should be marked by the client, and they should mark when you get into the later documents. If you see that their assets are higher, perhaps they own a house and they calculated that wrong. But most of them, that's pretty self-explanatory, and they can figure that out on their own. All the documents must be signed where the signature requires it. Again, that's fairly self-explanatory, but do want to have them sign it close to the time they're going to be filing it. The next form is blank for legal services clients because they don't have an attorney. So that's pretty... They do have to inform the court. Clearly they're aware that there's consequences with filing bankruptcy, and there's financial consequences and legal consequences. Obviously it's a crime to lie to the bankruptcy court. So everybody's going to mark yes because they know it's a crime to lie to the bankruptcy court. Legal services doing this pro bono program does not mean that you're a bankruptcy petition preparer. You're not preparing these documents for them. You're just reviewing them. And that's an important distinction because the court tracks bankruptcy petition preparers. They're non-lawyers that can help fill out documents, and they charge a fee. There aren't many of them in Montana. It's pretty rare. In bigger cities, that's a much more common thing. And a lot of them make errors, so the court wants to track those to make sure that the person's doing it correctly. The next form is an application to have the fee waived. Again, this is a document that fills in from the later forms, so it's something where you have to match. So I always tell the clients, you can fill this out last. They should already have it filled out. The numbers should match the later schedules. This is what tells the court that the client is, or the debtor is beneath 150% of poverty. Sometimes the question about tell the court why you're unable to pay, someone wants to write a book in there about all of the struggles they're having, and that's understandable. The court just wants to know they're below 150% of poverty and that they don't have an ability to pay, which is a term of art. Unable to pay or an inability to pay just means that they don't have a net worth of greater than about $75 a month. Because if they can pay the fee in installments, that would be preferable to the court than waiving the fee. Again, they're going to ask the same questions about did you pay anyone to help with the bankruptcy. And again, that would be an answer of no, because they are not paying legal services and they're not paying a petition preparer. Does anyone have questions about those first two forms? All right. The next form in the packet is called a summary of your assets and liabilities. Again, this is a form that it's in the front of the forms for the bankruptcy, but it's filled in from later forms. So, for example, they're asking for a total amount of personal property, and that'll come from Schedule AB. So it's going to come from documents later in the packet. So you just want to make sure with the client that the numbers match the schedules that are referenced. As you can see, for example, they're referencing the number of debts that you have taken from the number of what your assets total. So it's pretty self-explanatory as long as you have the rest of the forms filled out. So it'll reference, for example, on your income, it references Schedule I, which is where we'll put the income, and you just want to make sure the numbers match. This court tracks certain kinds of debt for statistical purposes. So if you owe child support, that is something that would be listed here in the top one. In this particular sample, that no one owes child support, but that is one that could be an issue with legal services clients if they're behind on paying child support. Sometimes there's taxes and other debts to the government. It's not your job to tell them whether or not these will be discharged in the bankruptcy. You know, they're priority debts, which means likely they will not be discharged in the bankruptcy, but it's not your job to figure that out for them. The court will figure that out for them. It's important to list them is the main thing. Student loans will come up sometimes if the client owes student loans. The court tracks those for statistical purposes as well. And so again, you'd just be copying the number of how much they owed on student loans to this form. So it's just a double check, basically. If you go back to the instructions that are given to the clients, page 2 of the instructions, you'll see as we're going through these schedules, which are the next set of forms, there's instructions given to the clients. For example, this next schedule is the client's assets, and it tells the court what you own or are buying or are leasing. So if you own a piece of property, it's listed, even if you have a debt against it. And of course, all of the assets that you have that you own outright are listed as well. Most all, like I said, of this property will be exempt. And there is a court form that they fill out with their personal property list, so they don't have to guess what property they have to list. It goes through and it says couch, love seat, dressers, and those sorts of things, and the client will have filled that out before they come to you. So it's just important to note that they should have it. So if you go back then to the actual schedule, it starts with real property. In my example, the person does not own a house, but if they do, they have to fill out where the property is and to describe it to the court. But most clients do have a vehicle. So you just list the vehicle. It's pretty self-explanatory, the type, year, mileage, and the location. Again, these would already be filled out, so you're just scanning down to make sure they are filled out. cut off a little bit, but the household goods come next. And again, these are pretty self-explanatory. It says household goods, then you fill in the household goods. They don't have to list everything that's on their attachment, but just as an example, I listed out an example of what property people typically own. Next is electronics. Again, this comes from what they've already filled out. It should already be filled out. A lot of these things people don't have. Like maybe they don't have any collectibles that have great value like antiques. So a lot of these will just be no. In Montana, it's fairly typical to have a gun when you're filing bankruptcy, or even if you're not filing bankruptcy. And so you list those out as well. Sometimes people ask, how do you come up with values for something like your gun? You are supposed to look to a common market where you could sell it. So, for example, guns, there's websites like gunbroker.com, or you could take it to a pawn shop. That's where they should be looking for values if they ask. They don't want to just pull the number out of nowhere, because the trustee might ask, how'd you come up with that value? And so it's important that they know where they came up with the value from. And that's true for all of this. Again, the court's not looking to take your household goods. They don't want your couches and your beds and your dressers. It's just a matter of disclosure, because in bankruptcy, disclosure is the key. You want to make sure you got your stuff out there so the court knows that you're telling the truth and you've put out to the court everything that you own. Same with like clothes. I mean, the court doesn't want your clothes. You have to list them. They even want to know if you have pets. So you have to list your dog and your cat. I made up values for them. I always put dogs at $25 and cats at $15. Unless they have some sort of stud value, or you're really, you're looking at a racehorse or a thoroughbred, the court doesn't want your dog and cat. They're not going to be able to sell them for anything. So then you total this up. Each section, there's a total. A lot of clients don't have any cash when they file. If they do, you'd list the small amount of cash they might carry with them. Most clients do have a bank account, some do not. So if that's blank, you wouldn't be surprised. But I always say, do you have a bank account if I see that it's blank? But otherwise, the bank account goes in with the amount of the balance as of the day of filing. So when you're reviewing these, sometimes the client's going to take a while to complete the forms after you've reviewed them. If there's errors, or if they don't feel like they're complete enough, you need to let them know that those numbers should be put in right when they're filing the forms. The court's interested in what's in your accounts the day you file, not a month beforehand. Well, that's not necessarily true. They are interested in a month beforehand, but not on the form. You'll see a lot of these next things are all marked no. Most people don't have bonds and stocks. But like we've talked about, people do have retirement accounts. And again, no matter the amount that's in that account, it's all exempt. So someone could have $100,000 in their retirement account and still file a Chapter 7 bankruptcy. Legal services clients don't have $100,000 in their retirement accounts, but it is a possibility. Often someone might have a security deposit. I didn't list one in this sample, but if they have a security deposit on hold with their landlord, that's what would be listed there. The court's always interested in things that most clients don't have, even if they're private debtors, like an educational IRA. But when you're reviewing the forms, I just go through and say, do you have one of these? Do you have one of these? Do you have one of these? And usually the answer is no. They've already marked no, but you're just trying to confirm that they filled it out correctly. So you just go down the list and ask, did you have this? Depending on the time of year, number 28 there is tax refunds. If you haven't gotten your tax refund, then that's something that you're already anticipating, so you might know the value of it. In general, it's not smart to file a bankruptcy while you're anticipating your tax refund. So there's, like I said at the beginning, there's no exemption for cash. Well, the tax refund is considered cash. And so the bankruptcy court could take your refund if you haven't spent it before you filed. So I always advise that the client get their refund at this time of year and then spend it before they file their bankruptcy. Family support is where past due child support or alimony or other types of maintenance go. And like I said, it's pretty common for people to have back owed child support. It doesn't mean you're going to get it. Sometimes clients say, oh, do I list it? I'm going to get this somehow? No. Can't make their spouse pay or ex-spouse pay or other parent pay. But it is 100% exempt, so that number could be anything. The court will always ask if you can sue somebody. That's number 33, claims against third parties. So if your client says, oh, I have this med mal case pending, you know, I can sue my doctor, well, that's something they'd want to list. Often they don't know the value. I mean, a claim like that could have no value. So you can say unknown for a value on something like that. I didn't list that in this example, but they would need to describe the claim. And that's something the trustee is looking for as an asset. They could go after the proceeds of that damages if there were a viable claim. And the trustee wants to know that answer. Part 5 and Part 6 are usually no's. And then you just go back, and this is a summary. And it tells you exactly what to go back to. So the clients are, you know, they're looking at this. It says total real estate. Go back to line 2. Personal and household goods. You go back to line 5. So they're going to tell you where to go. So again, the numbers just want to match. You're not refilling these out or recreating the wheel. You just want to make sure the numbers match those lines. A lot of bankruptcy and a lot of the role of the pro bono attorney is just to make sure the material's in the right place. It's not your job to fill out the forms. Remember, it's your job to just help the client know if they're ready to go to the court. Does anyone have any questions about the assets?
Jennifer, and if I can just point out on the one thing I didn't talk about in the introduction, but legal services, we can't help people that have a lot of assets. We have asset caps based on your household size. So if a client's coming from legal services, they're not going to have a piece of property worth $150,000 because we wouldn't be able to help them. We can exclude a vehicle and their home where they live, but that's it. So it does, just the nature of the clients and our rules and regulations kind of ensure that hopefully the assets are fairly straightforward and simple. Most of our clients, zero or close to. So I just wanted to explain that part of it and the screening that we do internally.
And that is why, one of the reasons why almost every single case will be a no asset case. Everything we just listed here will then be listed again on this form. Now, this is the form that clients have the most difficult time filling out. And this is because this is where the law goes. So the important thing is everything you listed on that Schedule AB, from your car to your household goods to your clothes, is going to be listed again. So you list your car. In this example, there is a car loan, and we're going to get to that next, but there is a car loan, so you're looking at the equity in the car. And then you list the code section. So, for example, Montana Code Annotated 2513-609 is where you find almost all of the exemptions that are important, and 6092 is an automobile. The clients will often come in either with this totally blank, or they'll not have any law listed. And that's okay. That's probably the most complicated form they have to fill out. Like I said, they don't know the law. They are given that same list of exemptions you are, and they're given instructions about how to fill it out, but that doesn't mean it's something that's easily done. Like I said, it just duplicates everything you just listed on the form before. And it is important that they all be on this form because this is what allows them to keep it. So this form's very important to the bankruptcy, but it's just a little difficult to fill out. I often will just start and tell them the first couple examples, and then tell them they're going to have to go back and fill out the rest of it. You don't have time when you're doing the review to necessarily go through and let them fill everything out while you're talking to them. And that's important to remember. You usually have about an hour. Is that about what you take, Chuck? Hour and a half? Okay. Mhm. That's important. So, like, one of the things the form does is break out electronics and household goods and firearms, and they're all the same code section. So the court's going to accept it if they combine those together. They're not going to say, oh, you didn't fill out line 12.1, because they're looking to make sure that they're exempt. I do it this way because I have bankruptcy software, and it automatically populates this form. So I just have to list in their assets and all of it, and click the exemption, and this form gets generated. So it's a little easier.
If I can just clarify too, we do try and split people out between phone advice, over the phone appropriate, and somebody that needs to meet in person. And generally what we're looking for is whether they can read and write well enough to do the forms themselves, or whether there's a mental health issue or traumatic brain injury, something that's going to make it really difficult for them to do it on their own. So we try and make sure that people that really do need to spend the time and have an attorney fill the form out for them are meeting in person versus having a 1-hour phone appointment where it may not result in anything because they're just not a good candidate for that.
And I think that's an important segue to remember. There is another option for low-income people. There is the state modest means program. And so if someone wants to hire an attorney to do their bankruptcy, if they qualify for legal services, they also qualify for the modest means program. And under the modest means program, bankruptcy attorneys are allowed to charge $600. Which is about a third of the going rate for a Chapter 7 bankruptcy. And so there are attorneys that participate in that. Unfortunately, there aren't enough. I just had a call. I live in Missoula. I had a call from someone in Havre. They'd been sent 2 names of people they could call to do the bankruptcies, and one of them was a public defender who's never done a bankruptcy. And the other didn't do pro bono or modest means cases, so I don't know why they were on the list. But it is difficult sometimes to find a modest means attorney for bankruptcy, and that's just because of I think, the reimbursement level.
But to circle back to your question, if somebody has filled out their forms fully, then yes, I'm not as fast as you, but it's not much more over an hour. Yeah.
And I think that's important. And like I said in the beginning, you don't have to do this on your own. Chuck, myself, and there's other attorneys that do these regularly are available to mentor you so that, on your first one, perhaps you could sit together and do it. Or if you have questions before you do, the legal services is great about sending you the forms in advance so you can look through them before you meet with the client. And I find that really useful because you can kind of flag the areas where you see, oh, they left this blank, clearly that's a problem. And that's the biggest problem you see is they'll get stuck, so they leave things blank, which is typical. I mean, that's what we all do. You get stuck, you skip it to the next thing. So are there any questions about the exemptions?
And I'm sorry, I just got an email from somebody watching, and they asked us to summarize what Chuck said before I remembered to get you the microphone. So I can pass that back to you or Jennifer if you want to. Sorry, not used to the live stream.
So Jennifer had asked me, to whoever's online, whether or not it took me about an hour to do these. And the context behind that question is, I think, one, I've got some experience, and I get given cases that are, the paperwork isn't completely filled out yet, so it tends to take me longer. And the answer, though, to the question was when the paperwork's filled out. Yes, it takes around an hour once you've done a couple of these. I'm a little slower, so it may take me maybe 90 minutes, but not much more than that.
And I think that's fairly typical. Over the phone, I usually give 90 minutes because it's a little bit more difficult to do these over the phone because you have to make sure they're looking at the same page you're looking at. And you have to give them time to note the changes. Again, I don't give them time to make all the changes because there's just not enough time in that call. They're allowed to go back and make some changes and even get another appointment if necessary to talk to a pro bono attorney again when their forms are more complete. It's not your job to complete the forms. It's great that we have that available with experienced attorneys, but for the most part, you want them to be completing the forms themselves. So most people, even if they have older vehicles, often have debt against the vehicle. And so Schedule D is where you put those debts. If they own a home, the home mortgage would go here. And these are things that could be taken away from you if you don't have a reason to keep them. So, for example, here, the vehicle is worth a bit more than what's owed on it. So in my example, they owed $2,424 and the vehicle's worth $3,600. So it's fully secured. Often they're upside down, and so there'd be an unsecured portion. And that's just the difference between what's owed and the value. So it's fairly typical for there to be an unsecured portion. The court's interested not just in the type of vehicle, they also want the mileage. I don't know why, except for it has to do with value of the vehicle. But it's something that sometimes the clients forget. But it should be back on Form B, so it should just copy to Form D. So a lot of what you're doing here is making sure the things listed on Schedule A and B, particularly cars and houses, are listed again here with the debt that they owe on it. It's important that clients find accurate addresses. The court mails out a notice to all of your creditors. One of the things the client has to prepare is that mailing list, and it comes from these schedules. So on Schedule D, you'd have your secured creditors. You're going to use those addresses to send notice. So if they're inaccurate, you're going to be getting back notices saying, they were undeliverable. So mostly those come from credit reports. Clients are told before they file that they should pull their credit reports. And that's very important. You can pull credit reports for free. The government has a free site which is annualcreditreport.com, and the clients can do that beforehand. And again, they're told that, and they've already done it. The next form is where clients spend a lot of their time, because this is where they list their debts. Most of our clients don't have very many secured debts. The low-income debtor typically has medical debt, credit card debt, maybe some loans, and maybe some debt owed to the government. For in this example, that's the IRS. Part 1 of this form is where you list those debts like the IRS or the government. Court fines also go here. Court fines cannot be discharged. So if you owe restitution or fines to the court, you list them, but you're going to keep paying them. And a lot of the debts that go in Part 1, that is the case. Part 2 is where most of the debts go. They're going to be numbered, which comes into play later, so each one is just listed. You have to say who owns it. Usually it's just the debtor. Sometimes someone else owes it. For example, if you have medical debt from when you were married and now you're divorced, your ex-spouse could owe it. If it was a joint account, like a joint credit card, then there could be a third, a different party that owns it with you. But usually it's the debtor. In this first part, you're listing the actual creditor. And that's sometimes confusing for the client. So let's say you have this Chase account, but now some third party's collecting it. So it might be a different debt collector that's collecting that debt. You just put the creditor here because you're going to see there's another place where you put that collection agency in. And just like linking your exemptions to your asset form, you link the creditor to whomever is collecting for it. And that can be a little confusing. Medical debt is typical. Things like cell phone accounts are typical. This is just an example, so clearly I wasn't listing all kinds of debts in this example. So this next section, which is part 3, and on page 4 of this form, is where you put those collection agencies in. And you can see they reference back to those previous lines. So you just want to make sure they match up. And that's sometimes confusing to the client. They might have already listed the collection agency as the debt. It's not fatal. It's just best to give notice to the creditor and the collection agency. The court's not going to reject their form if they have collection agencies listed where typically the normal creditors go. So a lot of times clients get panicked when you get to this point because they've spent a lot of time filling out this schedule. They've listed out all their debts. They could have, 80 different people listed on this. And so it's important to know that if they did put a collection agency in the wrong place, the court's still going to accept that debt. Accept that schedule. If the person has been sued, so there's a judgment against them, or there's a case pending, you also have to give notice to, the attorneys. So they should know that if they've been sued, that's in the instructions, but you want to give notice to the attorneys so they can inform the court that the case is no longer, if it's pending, it should be closed. You also give notice to the court. So, for example here, the Missoula County Justice Court.
Jennifer, sorry, can I ask a question? I'm getting emails from our staff that are listening. One asks how a client would know if some priority debts are discharged. The discharge order doesn't really list what is or what isn't discharged.
Right. Just because a debt's priority, let's say taxes, doesn't mean it's non-dischargeable, which means if you owe taxes from the last 3 years, they're not going to be discharged. The client can put unknown for the priority amount because the court's going to figure that out. If you don't know the total of the taxes you owed, you can say unknown. The IRS is going to file something that says how much you owe, or the Montana Department of Revenue is going to say. So it's not, they don't have to know whether it's dischargeable or not. The court knows, and the trustee is going to be able to do that. I often put unknown on whether or not it's priority or whether or not it's non-priority.
I'm sorry, can I ask another question? I think all of our staff must be watching on a live stream. The question is, does the Montana Bankruptcy Court require the client to file the last 2 years of taxes, even if the client isn't otherwise required to file taxes because all of their income is Social Security?
No, and you do not file tax returns with the court. Tax returns, there's a place later that we may or may not get to that where you list what your adjusted gross income was from the last 2 years of your taxes, so you need those forms to fill it out. If you don't have to pay taxes, that number is 0. And so you don't have to have tax forms to give to the trustee. When they send you a list of the documents you need to send, you just have to say, I'm not required to file tax returns, or I didn't file tax returns because I didn't have to. And the trustee understands that. It's pretty typical with people on Social Security.
Thanks. Another question from online. Can a client sell their house during the bankruptcy, and if they do, will those funds be exempt?
You don't want to sell your house during the bankruptcy is the short answer. If it's sold after you file, technically it would be okay, and there's rules, but it's not exempt once you sell it because it's cash. And so if you sell your house and you have a load of cash, it's not exempt. The exemption ends when you sell the house. So like the other forms, there's a spot at the end where you total these up. And again, that just comes from the previous sections of the form. A lot of this is do the form, total the form. Do the form, total the form. It's cheating when you're an attorney because it does it all for you. You don't have to do math. It's a lot harder to do this on your own. Because all attorneys use software that self-populates those sorts of things, so you don't have to sit there re-adding it. But the clients do. Those doing it by themselves, they have to make sure that they've added them up correctly. I always assume they have. If I see a really small number there and I've just read through a lot of debts, of course I might say, hey, did you miss some of those debts when you were totaling? But for the most part, you're going to see that the number looks accurate. The next form are for leases. This is often blank. The only lease that typically is listed here is if the person has a lease for their rental. They have a lease for their rental, they would list their landlord, name and address. And when it says state what the contract or lease is for, it would be for my primary residence. If they're living with someone and they don't have a lease, or they're living with their parents, even if they pay rent, if they don't have a lease, this would just be blank. The other type of leases that come up very rarely are auto leases. Most of our clients are usually paying an actual lender for their car and not a lease agency.
If you're a renter, your lease has expired and your month-to-month, is that?
You don't have to list it.
Okay.
In this example, the co-debtors are blank. Co-debtors are obligors that also owe on your debts. So when I was talking about filling in your debts, if your spouse owes on your medical debt or you have a joint credit card, this is where you would list that person. And you'll see, just like everything else, they want you to refer back to the schedules and the line for the debt that you also owe with someone else.
From online, what is a good software to use?
Well, I'm not here to promote software. I use what's called Best Case Bankruptcy, but there are other bankruptcy software and I don't know enough about the other ones to really say, oh, I think this one's better for that reason or another. The client is not going to be using software. So, this next form, you fill out their income. The court wants to know where people are working. So if the person is not employed because, let's say, they're retired or they're on disability, this would say not employed and then disabled or retired or whatever the appropriate circumstances. For most people, you are going to have a job, what the job is, and who they're employed by and how long. And the court's going to ask them again with a trustee, when they go to their meeting, they'll say, are you still employed at the same place? So you definitely want to have that filled in. This schedule is looking at your income currently and going forward. There's another place in these forms where they look backwards, but here they're looking forward. So when it asks for your monthly wages, it's important that you give the typical average. Some people make different amounts each month. It's obviously easier if you're on a salary or you always work 80 hours and you get paid the same amount for all those hours. But sometimes that's not the case. If you work seasonally, you might make more in the summer and less in the winter. It's important to do an average then because you're looking at your total income picture. One of the things that the debtor has to give to the court are 60 days of pay stubs, so the trustee is going to be able to see from your pay stubs if this is accurate. And they need the pay stubs in order to fill out the forms, because that's where they're going to find what taxes are taken out. It's pretty self-explanatory here. Most people have taxes taken out. They might have retirement taken out of their pay. In this example, she works for a school, so it's mandatory. It comes right out. If it's voluntary, it goes in a different line. Some people, if they owe child support, they have it taken right out of their check. So that's another one that comes up. And if they have anything else, I always ask, do you have anything else that's coming out of your check? Because sometimes it's not something that's listed. It could be a different example, like work uniforms might come right out of their check. There are other types of income. If someone owns their own business, the court's interested in income and expenses. That's not that typical with legal services clients. But at the top, you're only doing W-2 wages. Interest and dividends are very rare. Family support payments are fairly typical. So if they're receiving child support, that goes under family support. Again, unemployment's not that common. When someone's unemployed, they're usually not thinking about filing their bankruptcy, but it could be that they're receiving unemployment. Social Security is a common one. The court, while you don't have to file taxes, the court wants to know what your source of income is, how are you living. So you do need to list Social Security here. Another benefit that a lot of legal services clients are receiving are food stamps, which is called SNAP. And so that is considered income for bankruptcy purposes. And so you need to list that they're receiving that SNAP benefit. if someone's receiving SNAP, you're going to know they automatically do qualify for that fee waiver. You have to be below 150% of poverty to get SNAP benefits too. So, in fact, you have to be even poorer. Again, you go through and you total these, and then you total the total amount of your income. If the client is married, there's clients that are filing together, there's another column you can see here to list the spouse's income. Even if your spouse is not filing, this is a form where you need to list both incomes. They're interested in your household income for purposes of determining what your income is and what your expenses are. Down here, they're going to ask, do you think this is going to increase or decrease? So let's say you know you're getting a new job, or you know that you're going to get a raise. Those are the two most common things. Or you know you're going to be laid off, so it would be decreasing. Any questions about income? All right. The next form are your expenses. The court wants to know your household size when figuring out your income and expenses. So this is where you list your dependents that live with you. It's pretty self-explanatory. It's fairly common for, even if you have children that don't live with you, you list them, but you would be checking the box no that they don't live with you. They're interested in those that are living with you for determining your household size. Sometimes I get the question, what if I have my 20-year-old living with me? In Montana, they don't count adult children as part of your household size. Unless they're a disabled adult, you can usually count them. But then you would need to count any income you're receiving for that person as well. So if you do have a disabled adult child and they're getting Social Security, you'd want to include that because your expenses are going to include that person's income in making the expenses.
Sorry, and I'm going to make you repeat it into the microphone, okay?
I was just wondering if it counts as living with the individual if they're on a part-time parenting plan or custody schedule.
I would say if you can claim your child on an off year, often it's, I claim the child one time and I claim the child the other. If you're in like a 50-50 type situation, yes. If you're not, such that the child lives primarily with the other parent, you wouldn't, but it's sort of a gray area. Because if they're with you a third of the time, you obviously have expenses for that child as well. So. All right, so almost everybody's going to have rent. Something that comes up with legal services clients is if they have subsidized rent. If your rent is $900 but you're only paying $300, you'd put the $300 here. You don't need to list the subsidized part because you're not getting cash for that. The subsidy goes directly to the landlord, not to you. So there's no place to list it on the income, and you don't count that portion. If a person owns their property, that's where the mortgage goes. If you own the property, often real estate taxes and insurance are included, but if they're not, you would list those out separately. Home maintenance is usually, that's something that would be for home ownership. So, if you have to set aside money so that if something happens to your property, that comes up each year. And that is important. These are monthly expenses, but sometimes we think of expenses as a full year. So if I think, okay, I'm going to need $500 or $600 of money set aside, then, that number would be 50. You wouldn't put 600. You'd put the monthly amount. These are pretty self-explanatory, and the clients usually do really well with this schedule because it's broken down so much. It says electricity, it says water, it has your phone and cell phone and internet. Usually there's not much beyond what is already pre-printed on this form. Food, if you remember on this example, there was a SNAP benefit. You do include that because you're listing it as income, so your food should be your total amount spent on food, including your food stamp benefit. Almost everybody spends over their benefit. The benefit amount is not enough to buy groceries for the full month. It's enough to supplement your income. Yes, that is very true. That's important. The debtors often, they'll have this filled out, but when you look at the bottom and they have their full income and then their expenses, this number might say 150. So then I always ask, do you have $150 left at the end of the month? And they'll say, well, no, I'm in the negative. And so then you want to go back and say, what is it that you're underestimating? And a typical one is food. Food is very common because they forget, oh, I eat meals out on top of what I spend at the grocery store. I run into the gas station and grab a Red Bull and a beef jerky. Well, those things aren't free, and they are part of your food budget. And so that is one that can be adjusted. Another one where they underestimate often is their medical expenses. Most of the legal services clients' medical expenses are fairly low because most of them qualify for Medicaid now that there's Medicaid expansion. And so their copays are quite low. But they do spend money on things like ibuprofen, over-the-counter meds. So if that number is 0 or a very low number, you want to ask, did you include everything that's medical that you expend money on? Eye doctors, dentists, things that aren't included in your insurance. They do allow you to list your expenses for your child care or education costs. So if your child's in daycare, you would list that. Transportation is another one that's sometimes underestimated. It's not just your gas they're looking at. They're also looking at maintenance of your vehicle there, which, if you need to get oil changes and get tires, or you drive an older vehicle and so there's constantly something going wrong. You need to make sure you include that amount in the monthly amount as well. They do separate out personal care products and services. So a lot of people in their groceries think I should include my shampoo and my razors and things there. The court actually wants them separated out. So personal care services include things like getting your hair cut. So if someone has 0 in personal care, I usually go back and say, did you include that in your food? Do you pay for haircuts? Maybe they don't pay. But it's just if things are 0, you want to make sure why they're 0. Entertainment, you are allowed to spend money on entertainment. That number is usually fairly low because there's not a lot of excess income in a legal services client's budget. It's very important that there be vehicle insurance if there's a debt against the vehicle. You're required to carry insurance in Montana, but you're not going to get in trouble if you don't have insurance and you own your vehicle outright. The trustee's not going to be like, oh, you're violating Montana law, here's a ticket. So it's important, though, if you do have a vehicle that you owe money on, that you must have insurance. So there should be an amount listed there. Typically, there's not an amount for health insurance because if they're paying for insurance through their employer, that would be on your income, so you would have already taken it out. Most people who get insurance through their employer, they don't have a number there. If they are paying for health insurance separately, like such as on the exchange, there would be a number there. The Although, like I said, most legal services clients qualify for Medicaid. Taxes would just be if you owe back taxes. So let's say you're paying on your tax debt to the IRS. You've already listed your property taxes somewhere else, so this is just like if you owe taxes to the state of Montana or to the IRS. Car payments. If you listed that you had a car loan, then you have a car payment. It's pretty self-explanatory. If you're paying child support, that would be listed as well. Something that comes up that people forget about, if they listed they had a dog and a cat, they must feed them or take them to the vet once in a while. And that's not free either. I have dogs. I know how expensive it is to feed them. And so that's something to remind them if the numbers looks, hinky. And that is important. Like Chuck said, they'll often come in with a number that looks too high there at the bottom. In order to qualify for the fee waiver, they can't have a number that shows they could pay it in 4 payments. I think that's $74.50, but I'm not great with math. So, 83 now? 83. Well, okay, I always say you should have a number there less than $75, which is, I think, is a safe bet. You're definitely going to be lower than the 4 payments. And that's not hard to do. This number can be negative. A lot of people live where they're paying their, gas bill one month and then they pay their water bill the next month, and they really don't have enough income to cover their monthly expenses. And so that's okay if that number is negative. Does anyone have any questions about the expenses? This is a really simple form, but it's important. The court's going to ask this question again when they come to their meeting, is if everything is true and correct in those schedules we just reviewed. It's a basic question, and then all they do on this form is sign it, but it is important. The next form is called the Statement of Financial Affairs. And this is going to be, it kind of takes a longer view of your income. It's going to ask more questions. That's why it's important to have things like your tax returns when you're filling it out. It's important to have documentation of how much SNAP benefits you've gotten. It's important to have documentation of what your Social Security benefit is. Each question is pretty self-explanatory, especially to a lawyer. They're not that complicated, but sometimes the clients get stuck on those. So they first ask, it's important if you've moved in the last 3 years, the court's going to want to know all of your prior addresses. One important thing is, let's say you've moved 3 times and there's not space here. For pro se debtors, they can add a blank page at the end. So it would say number 2 and then list the prior addresses. There's not enough space in the form. If you're using software, it expands and contracts, but you can't do that with just paper forms. And it's fairly common that our legal services clients have moved in the last 3 years. The court tracks if you lived in a community property state. Most people that answer is going to know. Most of our clients have lived in Montana. But it could be. So the next one is important. They're looking at your sources of income. So if you have wages, this is going to come from your most recent pay stub. So you look at your most recent pay stub and you say, what's the gross earnings to date? Again, this should be filled out. I always ask, did you use the gross earnings instead of the net earnings? Most people think of their pay in terms of net pay, They don't think of it in terms of gross pay. So I always double check that that is the gross income. The numbers from your tax returns, they look at the adjusted gross. So it's pretty, if those numbers are zero, that's fine. So for someone who's on Social Security, number 4 would just be all blank because they're not receiving any wages or income from employment. But then they ask next, other sources of income. So that includes things like Social Security, disability, SNAP benefits, child support. So you're listing what you actually received. So that's important for something like child support. If you were supposed to receive it, you don't list it here if you didn't actually receive it. Sometimes clients say, I don't know how much I got. Well, there's ways to find out. And one of the things when you're doing a bankruptcy is you have to do research into your debts, into your income. And so you can find out how much SNAP you received by contacting the Department of Health and Human Services. You can go online at this point and you can get that printed out. If you received welfare, or what's called TANF, you can get that printout from the state. If you're owed child support and you don't know how much the person's behind, CSED keeps a record. You can get a record from the state. So if someone tells me, oh, I don't have that or I don't know how to get it, there's almost always a way to get it. A lot of these are going to be blank, or the answer is going to be no. So for example, it asks number 7, did you pay money to an insider? Well, that's described there. Those include friends and family members and other relatives that you would have given money to instead of giving it to other creditors. So you're not allowed to do that within 1 year of filing the bankruptcy. So if they say, oh, I paid my mom back money, it's worth asking when that was. And it's important to know that within a year, they can take that back. And that means they can take it back from the person you gave the money to. One of the things at this time of year that the trustee asks is, how did you spend your tax refund? You can spend your tax refund pretty much any way you want, other than taking money and giving it to your favorite creditors. So if you got your tax refund and you gave $3,000 of it to your mom because she loaned you $3,000, the trustee's going to go to your mom and say, we need that $3,000 back. And that comes into a problem if they've already spent that $3,000. So it's important to know that you don't want to be giving money to insiders. This next section is another one where you might be adding additional paperwork. They're going to ask what lawsuits that you're involved in. Often the debtor has 3 or 4 different lawsuits pending against them for collection. Or they may have a divorce pending. That would go there too. But those are the typical things, or they're most likely a collection case. And that's what they're called. The nature of the case is just what type of case it is. They're all collection cases. I mean, fairly typically in a legal services client's case. Sometimes they'll say, I don't know. Like, I don't know if I have judgments against me. They should have been advised already, and it is in all of their instructions that they can go to the court, ask if there's judgments against them. It's important that they go to justice court and district court in Montana because the clerk's offices don't keep dual records. So, but they should be able to find those out. There's no reason why they shouldn't have that information. Next, it asks if you've been garnished. A lot of legal services clients are actively being garnished. That's why they want to file a bankruptcy. It's difficult to lose 25% of your net wages and survive, especially when you're low income to begin with. And so the court is interested in knowing how much has been taken in the year prior to you filing the bankruptcy. The debtor is given notice of the garnishment when it starts, and so they should know who is garnishing them. If they don't, they can ask their employer. The employer is given notice of who's garnishing because they have to send the check to that creditor. And so there's always a way to find it out. And you'll see most of these, I'm not going to read through all of them, but most of them are going to be an answer of no. For example, number 11 asks, within 90 days before you filed, did any creditor, including a bank, set off amounts from your account or refuse to make a payment because you owed a debt? Most people don't set off their debts against other debts. I mean, whether or not you're a legal services person or not. So these things are typically going to be no. Gifts. So if you've made gifts to somebody of greater than $600, again, typically that answer is no. Low-income people aren't gifting, $600. And if you gave money to charity of greater than $600, you might have an occasional person that does that, but again, most low-income people don't spare money to give to charity when they qualify for legal services. The court wants to know about losses because of fire, natural disaster, gambling. If when you were reviewing those schedules you see Lucky Lils as like one of their creditors, well then likely they have gambling debt. So I always remind people you might have lost some money from gambling. It's not a big deal. You might be a little embarrassed, but it's not a big deal. You just have to list it. Number 16 asks about payments related to bankruptcy. The typical legal services client, the only thing that's going to be listed there is that credit counseling that they had to do. You don't have to list an actual address. You can list the website where you got the counseling. Most people get the counseling online. The next question just asks if you paid anybody else within the year before your filing. So the promise to help you pay your creditors. That's typically a no as well. This is asking about transferring property. If the person says, I sold my snow machine to try to pay debts, or I sold my ATV, you would list that if it's in the 2 years prior to filing. And the court's just looking there to make sure you sold it for a reasonable value. So if you sold your, Harley to somebody for $1,000, but it's worth $6,000, the court's going to say, well, that's not a reasonable sale. But typically, most often the answer is no. They haven't had any property that they could sell to anybody. This could be something that legal services clients have, and that is that they've closed a financial account in the last year. So if they had to close their bank account or it was closed for them. So this includes if they closed your bank account because it was overdrafted and the bank closed it, you'd include that here too. You want to have all of this information. But again, if you don't know the last 4 digits of your old bank account, the court's not going to reject your petition because you didn't list those 4 digits. It's always best to have the information. If you don't know the exact date it was closed, a month and a year is good enough for the court. So if you knew it was in August, that's good enough. Same with the balance. If you don't know what the balance was and often it was negative, you can just put negative balance. Most people don't have safe deposit boxes. They might have a storage unit. I always ask, do you have a storage unit? That's what number 22 is looking at, is if you have property stored somewhere else. And number 23 is if you're holding property for someone else. Sometimes that comes up. Let's say you have adult children, they moved out, but they left a bunch of stuff at your house that's not yours. Well, then you're holding property for your child. Again, it's not a huge deal. You can just say who the owner is. This also comes up when someone's driving someone else's car. So let's say you lost your car and you're driving your mom's car. Well, then you just list that you're holding your mom's car. So you list the owner, your address, where it is. It's an 87 Accord, and the value, which would be probably 0 if you're driving an 87 Accord. Again, most people that's no, that there's nothing. The rest of this form, it's almost always no. People aren't holding on to property. That's an environmental hazard. That's so uncommon. It doesn't include the used motor oil in your garage. And the last part, again, these are if they own their own business. That's not very common with legal services clients, that they own their own business. Any questions about the statement of financial affairs? The important thing is if, yes.
Thanks. I don't have a question, but I've got to go. And I just wanted to make sure y'all Helena people knew if you end up doing these and you need some support doing them, if you have questions or you want somebody to shadow you or you want to shadow me, just get a hold of Angie. My name's Chuck Munson, okay? Yeah, and too, if you're considering doing pro bono, think about this. Maybe going through the packet, even though this is a great presentation, I've loved it. I think it's interesting, but I can recognize some people don't think this is the sexiest stuff.
What do you mean?
When you help somebody discharge their debt, the relief that they feel is awesome, and you really feel like you've done them a service. Like the amount of thank yous that I've gotten after doing this stuff have been really inspiring. So,
and I think that's important. I have people say to me all the time, isn't it depressing doing bankruptcy? Well, I did domestic violence family law, and you can't find much more depressing than that. And so I think bankruptcy is pretty rewarding because at the end, the person does get a fresh start. At the end of a divorce and you have kids, you still have to deal with your ex-spouse, and for a long time. That's not the case with bankruptcy. You do have a resolution and you have a new start. And I think that's important. And like Chuck said, people are so appreciative. This is not easy. It's not easy for people to do on their own. And so they're so grateful for the assistance that legal services is able to provide. There's only a couple forms left. This next one is only going to have anything filled in on it if they had secured debt. So if they had a car loan or a home loan, this would be filled in here. Because you have to tell the court what it is you want to do with that property. Do you want to surrender it because you can't afford it anymore? Do you want to keep it? And if you want to keep it, which is the case in the example here, you're going to have to reaffirm the debt in most cases. And what that means is that you're going to agree with the creditor to keep paying at the same terms you were paying on before your bankruptcy. And so there is additional paperwork that has to be filled out if that's the circumstances. They've been given that paperwork. It's not in these materials. It's It's not easy. I usually say you're going to want to make sure you talk to an attorney again, either at legal services or a private attorney if you're going to reaffirm the debt, because it's important that that be filled out correctly. But otherwise, you just list them here, and you list the leases as well. Like I said, that's very uncommon for the landlord. And if you do list a landlord under these leases, it asks, is the lease to be assumed? A lot of clients don't know what that means. All that means is you're going to continue to have your lease. So it's always assumed with a rental property, because unless they're intending to move during this bankruptcy, they're going to want to stay in their property. This form is for the court's records, and I always reassure the client that their Social Security number is not going to be in the public record, and that is the truth. They keep it in a sealed directory separate from the public PACER system, and so nobody can go look at bankruptcy records and get Social Security numbers. In fact, the clerks review everything, so if they were to file their pay stubs, for example, and their pay stubs have their Social Security number on them, the clerk is going to see that and let them know that has to be redacted from the record. But it's just important to tell them, don't file anything with the court that has your Social Security number on it other than this. But otherwise, that's obviously really self-explanatory. I always make sure that their number's correct. That's all you want to make sure that they're giving correct information to the court. All right, so there's really only two things left. So remember I said that Schedule I was your income currently going forward? Well, this form is your income going back 6 months. So you say whether you're married or not, and then your gross wages are going to come from your last 6 months of pay stubs. So you go back and you look, like right now it'd be October to March. You want to look at how much you made and divide it by 6. So if you only were working 3 months out of that 6, you still divide them all by 6. So it's just going to be lower than your typical monthly income. Social Security does not go on this form. The bankruptcy code does not count Social Security for your current monthly income. So this could be 0. You do count child support, and you do count SNAP. And veterans benefits come up as other income. They do count veterans benefits, even though they don't count Social Security. So that would go under other income. And then you total it. You come down and you take your current monthly income and times it by 12, and that will give you your gross income. They're given a chart that shows them what the median income is for each family size. So for example, this woman had 4 in her household. You're allowed up to $82,000 for a median income for a household of 4. And clearly every legal services client is going to be a below median income debtor, because median income is much higher than net income or average income. So if that number is not below it, something's gone wrong in your client's paperwork. This next form is several pages long. It's blank. I mean, it's not blank, but it's just something that the client has to read. There's nothing to fill in on it, so. Last thing the client has to prepare is the mailing list. So they sign that they've created it, and then they have to list everybody that's on their schedule. So if they're on, whether they're a secured creditor or those unsecured creditors like the credit cards, if they had a co-debtor, that address goes on here. And then they're required to include 2 addresses. One is the IRS, and the other is the Montana Department of Revenue. And they're told that in their instructions as well. There are 2 state forms, but they're really self-explanatory. Almost everybody doesn't owe. If they owe child support, you say yes. If they don't, you say no. If they owe child support, you fill in the information that's asked for. All right. Does anyone have any questions? Not. We're pretty much done then. I want to thank you for coming today. This isn't the easiest thing, but it is easy once you do them more than once. And so if you're in the Missoula area, I am happy to shadow you. If, like Chuck said, he's happy to shadow or have you shadow him. And I'm willing to do that as well. And there's probably a few other people that Legal Services has in their pipeline that would be willing to do that.
Yes, and thank you so much, Jennifer. Jennifer does so much for us, as well as being able to explain in 2 hours how to fill out several inches of forms. So we're really appreciative of that. I want to just encourage you. I will follow up with the people that signed in as attendees, not to pressure you into volunteering, but if you'd like to give you my contact information and also the number for this CLE if you want to self-report. We'll also send the letter to the state, or the list to the state bar for CLE credit. I think Chuck and Jennifer couldn't have said it better. Bankruptcy is a really nice way to do pro bono because it's a solution that is achieved through paperwork instead of through lots of heart-wrenching kind of family law stuff that we find in a lot of other pro bono cases. And Chuck is right. The relief that someone feels by the time somebody gets to bankruptcy, it's been years of collection agency calls, knowing they can't pay their bills, trying to figure out how to pay their bills. And so the relief of actually getting a clean record and a fresh start is really rewarding. And we get a lot of positive feedback about bankruptcy cases. You know, people are a little more appreciative than they are in family law occasionally. So it's a good, a feel-good way to do it. I also just wanted to clarify that we ask for help from attorneys for advice throughout the process, because what we find is if we say you got to have all your forms done before we're going to do a review, people stop at that Schedule C and they never finish it because they don't know, they have one question and it keeps them from filling out everything else. So when we send the forms, and typically after we've advised them and told them you really ought to file for bankruptcy, here's the forms, here's a list of what you need to do to start, call us as soon as you have a question. And we check in with them to make sure they don't, because what we find is if they have a question, that's the thing that keeps them from filling it out the rest of the way. And usually Jennifer or one of our volunteers can answer that question pretty easily.
And some of the questions are procedural, and the assistant at Legal Services, who's sort of the point person, can even answer it. So, or they can ask one of the attorneys at Legal Services. So there are people there to help you through this process.
We get a lot of questions about what color ink to use. Honestly, because it's in the instructions, it's a little confusing. So
I suggest blue.
All right, if there aren't any other questions, thank you very much for spending your long lunch hour with us. I'm sorry we did not provide lunch. We will do that next time if we have a larger pool of money to pull from to do it. Thank you for Jennifer to driving over from Missoula today. Thank you all.